It's a pleasure to welcome everyone here this morning for the last public meeting for calendar year 2013. This is the 20th meeting for the calendar year, and I'd ask everybody to join us in the Pledge of Allegiance.
Flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Before I recognize the Vice Chairman for purposes of editing the minutes, or the approval of the minutes, excuse me, I'd ask every employee here at the Commission to please stand. On behalf of the 5 commissioners, we'd like to thank you for a job well done during calendar year 2013. And seriously, thank you all for all that you've done, whether it was a public input hearing, Judge Rainey and the team at ALJ, our Chief Counsel, Cheryl Walker-Davis, for all the work that you've done with public meetings. I could go on and on and on. I'd ask everyone, including our commission staff, to please stand. We want to salute you for a job well done. Tom Bean, please stand up again. Well, the first matter on this morning's agenda is the approval of the minutes of the November 14th public meeting, and it's a pleasure to recognize the Vice Chairman as the editor of the minutes. Vice Chairman Coleman.
Thank you, Chairman. I have reviewed the minutes of the November 14th, 2013 public meeting, and I move that they be approved as submitted.
Second.
Any discussion? Any objections? Hearing none, the minutes are approved as submitted. It's a pleasure to welcome to the podium this morning to begin our public meeting, festively dressed, Ms. Cheryl Walker-Davis.
Thank you, Mr. Chairman. Good morning. Good morning, Commissioners.
Good morning.
Good morning.
May it please this Honorable Commission, on behalf of your various offices and bureaus, we present for your consideration and disposition the following agenda items, commencing this morning with matters on behalf of the Bureau of Administration. On page 1, it is recommended that the Commission adopt the recommendation to approve the low bid for outside legal services for human resources work.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
On page 2 of the public meeting agenda, on behalf of the Bureau of Consumer Services, it is recommended that the Commission adopt the recommendation to issue the tentative order in the proceeding involving the final amended Universal Service and Energy Conservation Plan of Duquesne Light Company.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
Turning now to matters on behalf of the Office of Special Assistance, it is recommended that the Commission adopt the staff recommendation in the first item pertaining to the interconnection arbitration proceeding involving Core Communications and CenturyLink, noting the statement of Commissioner Brown as well as the oral statement of Vice Chairman Coleman.
I'd like to recognize Commissioner Brown for purposes of her statement. Commissioner Brown.
Thank you, Mr. Chairman. I'd like to submit my statement for the record, but I would like to highlight the following. This case is a disputed arbitration between an incumbent local exchange carrier and a competitive local exchange carrier under Section 252 of the Telecommunications Act of 1996. This section gives the Commission the authority to resolve disputes between CLECs and ILECs about the terms and conditions governing their competitive relationship, typically interconnection and rates. I disagree with the majority's decision in this case for 3 reasons. First, the decision imposes an immediate bill and keep rate of 0 only on competitive local exchange carriers like Core instead of the 0007 per minute of use rate cap imposed by the FCC on all dial-up interconnection in the ISP remand order. A bill and keep rate of 0 may undermine our precedent as well. I would have preferred staying at the 0007 rate or at a minimum at an interim rate of 0035 per MOU as an effective compromise because this reflects the FCC's new called party pays theory in the ICC USF order. The immediate imposition of a dial-up rate of 0 does not. The application of this 0 rate raises potential rate discrimination concerns prohibited by state and federal law. A rate of 0 is immediately imposed on the CLECs while ILECs continue to get compensation for interconnection until 2017, 2018, or possibly 2020, depending on the carrier's classification and ownership of tandems. Second, the decision narrowly defines the network of an ILAC when it comes to a point of interconnection under Section 251C2. Today's decision treats an ILAC network as equivalent to a local service territory. They are not the same. Carriers routinely extend their local service network using equipment and facilities to third-party tandems. Also, the courts recognize that network is undefined in Section 251C2. The majority does not address these concerns. Third, the decision suggests that VNXX arrangements are outside the scope of the ISP remand order and views VNXX differently than NXX. Today's decision also limits the dial-up interconnection sought here to a local calling area, typically a rate center. That is not consistent with prior practice. For these reasons, I am voting no on this matter. Thank you.
Thank you, Commissioner Brown. Any further discussion?
Chairman, I also wish to be recorded as voting no.
So noted. Commissioner Cawley, I'd like to recognize the Vice Chairman Coleman for purpose of an oral statement. Vice Chairman.
Thank you, Chairman. From time to time, we have these cases that come before the Commission that are very complex, and certainly interconnection agreements are no exceptions, as we're seeing here this morning. I just wanted to take a moment to thank our OSA staff, particularly Andy Showers, for doing an excellent job with this piece, as well as our Commission staff. This is a complex matter, and they have spent an inordinate amount of time getting it right this morning, so I wanted to publicly thank them for their time and effort.
Thank you.
Thank you, Vice Chairman. I also would like to associate myself with your statement. Is there any further discussion? Noting the objections of Commissioner Brown and Commissioner Cawley, the motion passes 3-2. Excuse me, I'm being reminded we need to formally move the core communications petition for arbitration. Can I have a second, please?
Second.
Any further discussion? We noting the objections of Commissioner Brown and Commissioner Cawley, the motion passes 3-2.
Continuing with the presentation of agenda items, it is recommended that the Commission adopt the staff recommendation in the proceeding involving the informal investigation of Public Power LLC, appearing at the bottom of page 3 as well. On page 4, it should be noted that the recommendation in the proceeding involving Larry Moya versus PPL Electric Utilities Corporation has been postponed. The omnibus continues with a recommendation to adopt the staff recommendations in the Barbara Pizzuto versus Metropolitan Edison Company proceeding, as well as in the proceeding involving UGI Penn Natural Gas Company structured to shelter pipeline facilities in West Wyoming Borough, on page 5.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
On page 6 of the public meeting agenda, we recommend the adoption of the staff recommendation in the general rate increase proceeding involving the Pennsylvania American Water Company. Noting your statement, Mr. Chairman.
Thank you. For us for consideration today is a decision from the Office of Administrative Law Judge that recommends approving a settlement in the rate case filed by Pennsylvania American Water Company earlier this year. The settlement provides for an increase in PAWC's annual operating revenue of $26 million, or a 4.5% increase, which is considerably lower than the originally requested increase of $58.6 million, with a 10.1% increase. I commend all the parties here this morning for reaching such a beneficial outcome in this case. This settlement is undoubtedly in the public interest because it results in reasonable rates for customers and avoids the needs for further proceedings, saving money for the parties and customers. Additionally, this is the first case to implement all 3 rate-making tools permitted under Act 11 of 2012. In its filing, PAWC used a fully projected test year, and under the settlement, it will continue to use a distribution system improvement charge to fund infrastructure upgrades synchronized with the FTY, forward test year. Through the combination of these 2 rate-making tools, customers will receive the benefit of rate certainty for several years. This is in combination with PAWC's commitment to invest $10 million in water main extensions identified in the settlement. This means a real benefit to customers. The settlement also combines a portion of PAWC's water and wastewater revenue requirements for the purposes of setting rates. By taking advantage of perhaps the least recognized tool permitted under Act 11, the settlement significantly mitigates the rate increases for PAWC wastewater customers. Doing so would obviously prevent rate shock for those wastewater customers, and it only results in an increase to water rates of less than 1%. Additionally, PAWC's water customers will benefit in the future when large capital projects are needed and the cost of those water projects can be spread over combined customer bases. This settlement demonstrates why Pennsylvania continues to be a national leader in water and wastewater regulation. Thanks to the foresight of the legislature in passing Act 11 and the spirit of cooperation between all the parties, PAWC's water and wastewater customers will see real benefits as evidenced in this morning's settlement. Any further discussion? We're going to have to, excuse me, we'll call the motion here this morning.
Second?
Any further discussion? Any objections? Hearing none, the motion passes unanimously, noting my statement.
Should be noted on page 7 that the proceeding involving Kenneth Triber versus Pennsylvania Electric Company, the matter in that proceeding has been withdrawn. Continuing with the presentation of items, it is recommended in omnibus fashion that the commission adopt the staff recommendation in the formal complaint proceeding involving Lisa Martin versus Pico Energy Company, as well as the recommendation in the Fred Wilson and Columbia Gas of PA proceeding on page 9, and the recommendation at the top of page 10 involving both Elizabeth Borough and the United Telephone CenturyLink Lumos Network Interconnection Agreement.
So moved.
Second?
Any discussion? Any objections? Hearing none, the motion passes unanimously.
It is recommended that the commission adopt the staff recommendation in the interconnection proceeding involving Frontier Communications and American Broadband, noting the statement of Commissioner Brown.
So moved.
Second?
I'd like to recognize Commissioner Brown for purposes of her statement. Commissioner Brown.
Thank you, Mr. Chairman. Consistent with Section 1102 of the Commonwealth Ethics Act, I recuse myself from this matter because my brother is employed by Frontier Communications.
So noted. Any further discussion? Any objections? Hearing none, the motion passes 4-0, noting the recusal statement of Commissioner Brown.
In omnibus fashion, it is recommended that the commission adopt all of the items appearing on pages 11, 12, 13, 14, 15, and the first 3 items, well, all items on pages 16 and the first 3 items on page 17 through and including the application of Transnational Communications International, Inc.
So moved.
Second?
Any discussion? Any objections? Hearing none, the motion passes unanimously.
It is recommended that the commission adopt the staff recommendations in the next 2 matters involving Verizon Pennsylvania LLC and Verizon North LLC's annual price change opportunity filing, noting the statement of Commissioner Cawley with regard to both of these proceedings and the statement of Commissioner Brown with regard to the Verizon Pennsylvania LLC proceeding.
So moved.
Second?
I'd like to recognize Commissioner Cawley for purposes of his statement. Commissioner Cawley.
Thank you, Chairman. I ask that my very lengthy statement be placed in the record as if I had read it in its entirety. This is another one of those complex matters. I simply wish to note that I concur in the result only.
So noted. I would like to now recognize Commissioner Brown for purposes of her statement. Commissioner Brown.
Thank you, Mr. Chairman. I also would like to just submit my comments for the record, and I do support the filing.
So noted. Any further discussion? Any objections? Hearing none, the motion passes 5-0, noting that Commissioner Cawley is concurring in result only here this morning.
On behalf of the Law Bureau, it is recommended that the commission adopt all of the recommendations appearing on page 19 through and including the recommendation pertaining to Act 129 EE&C Programs Technical Reference Manual.
So moved.
Second?
Any discussion? Any objections? Hearing none, the motion passes unanimously.
On behalf of the Office of Administrative Law Judge, with regard to the first matter, it is recommended that the commission adopt A.L. Dejan DeBur's initial decision in the proceeding involving Vincent Wagner versus UGI Utilities Gas, Inc., Gas Division, noting the oral statement of Commissioner Cawley.
So moved.
Second?
I'd like to recognize Commissioner Cawley for purposes of his statement. Commissioner Cawley.
Again, thank you, Chairman. This is probably unnecessary, but I'm going to say it anyway. The ALJ found this account was a commercial account because it's an apartment building. And the record is really unclear whether there are tenants in this building or not. The record indicates that the complainant quote, has had, unquote, tenants in the building. The ALJ ordered the complainant to comply with the terms of the payment agreement issued by our Bureau of Consumer Services and stated that if the complainant failed to do so, UGI was authorized to terminate service. I would simply remind UGI that if it does terminate service to this building, that it first ensure that there are not tenants in the building. Or if there are tenants in the building, that UGI comply with Chapter 15 of the Public Utility Code, which deals with discontinuance of service to leased premises. Thank you, Chairman.
Thank you, Commissioner Cawley. Any further discussion? Any objections? Hearing none, the motion passes unanimously.
It is recommended that the Commission adopt ALJ Cheskas's initial decision in the proceeding involving Jenny Carter Harris versus Philadelphia Gas Works, noting the joint statements of Commissioner Cawley and Commissioner Brown.
So moved.
Second.
I'd like to recognize Commissioner Cawley for purposes of the joint, or Commissioner Cawley for purposes of the joint statement. Commissioner Cawley.
Thank you, Chairman. This is a lengthy statement. I won't read all of it on behalf of Commissioner Brown and myself, but we are anxious to preserve the Commission's traditionally broad interpretation of Section 1501 of the Public Utility Code, which requires that all public utilities provide reasonable service. Jenny Carter Harris believed that she properly enrolled in Philadelphia Gas Works' Landlord Cooperation Program, only to find out later that she was not enrolled at all. As a result of not being enrolled in the program, the overdue bills of Ms. Harris's tenant became the subject of a municipal lien on her property. She requested that the lien be removed and that PGW be required to transfer the payment responsibility for the gas bill to her tenant. The administrative law judge dismissed her complaint on the preliminary objections of PGW, which explained that the complainant created an account under the program, but she failed to register her rental property. By registering, Ms. Harris could have protected her property from the imposition of a lien, but she enrolled, but she did not register the property. The ALJ recognized that this commission lacks subject matter jurisdiction over municipal liens. But the ALJ further acknowledged that in situations where the commission has underlying jurisdiction over issues ancillary to a municipal lien, the commission may retain jurisdiction over those underlying issues. Commissioner Brown and I would go further. We disagree with the conclusion of the case, which ended with the granting of the company's preliminary objections. The legislature purposefully included customer service issues within the jurisdiction of the commission when it enacted Section 1501. If the commission does not entertain these issues, then to whom does a customer like Ms. Harris complain for a redress of utility service-related grievances? We believe that the Landlord Cooperation Program, although voluntarily provided by PGW, falls within the ambit of Section 1501, which requires public utilities, as I said, to provide reasonable service. The program assists residential rental property owners to avoid the imposition of gas liens on their registered properties, to help PGW with necessary meter access, quote, for any reason, including but not limited to shut off or turn on of service, meter maintenance, performance of a leak survey, or for other safety or operational reasons, and to assist PGW in the timely collection of payment for its services. So this isn't just for landlords. It benefits the company and its other customers substantially. Although not tariffed, with us and not and it is because it is a voluntary program. The program and many of its features relating to failure to pay accounts, to access meters, meter maintenance, and leak survey access are, we believe, inextricably intertwined with the provision of PGW's utility service. According to PGW, the property was not registered until February 25th, 2013, 10 days after the lien process was begun by PGW. It appears from company records submitted into evidence that a PGW employee helped Ms. Harris ultimately enroll in the program, but it is not clear whether PGW assisted her in registering her rental property. A lien notification letter was ultimately issued on March 18th of this year. Emails between Ms. Harris and PGW's program managers show that Ms. Harris was having trouble navigating the PGW program website. She clearly asked to have the manager call her and provided her callback number. There's no evidence that anyone from PGW returned her call. She obviously wanted to enroll in the program so that she could register her properties to secure the protections afforded by the program. There was no other purpose in enrolling. She succeeded in the first, that is, she enrolled, but she failed in the second, that is, registering on the website, which she alleged was not customer-friendly. Because the case was dismissed on preliminary objections, a complete record was not developed to determine whether or not reasonable customer service was provided to this customer within the meaning of Section 1501. Consequently, Commissioner Brown and I believe that the matter should be remanded for a determination of the reasonableness of the customer service provided by PGW. Finally, we cannot help but wonder why this matter was pursued by PGW and why the company did not simply acknowledge that Ms. Harris plainly meant to register her property and, but for the apparent difficulty of doing so, would have succeeded, especially if the company had answered her request for assistance. Of course, it is not too late for PGW to make amends. Thank you, Chairman.
Thank you, Vice Chairman, Commissioner Cawley. Let me just, before we get into the vote here, let me simply add, and I agree with many of the things you said in regards to 1501, and I would say 1501 North Broad Street needs to do a better job managing this case for this customer, because some of the things you outline in terms of the enrollment piece, that box is obviously checked. The registering of the property was not. And I think that if anybody in this audience representing PGW had heard this joint statement here this morning, or you're listening on our YouTube network, I would encourage you to get back at this case, because I do agree with some of the things that have been outlined in your joint statement. But again, 1501 North Broad Street, that's supposed to be representing customers, could do a better job here this morning. And I agree with some of the things, again, in your dissenting statement. Any further discussion? Any objections? Hearing none, the motion passes 3-2, noting the dissenting statement of Commissioner Cawley and Commissioner Brown.
Continuing with matters on behalf of the Office of Administrative Law Judge on page 21 of the public meeting agenda, with regard to ALJ Pell's initial decision in the proceeding involving Stephen Merrigan versus Pico Energy Company, there is the motion of Commissioner Brown.
I'd like to recognize Commissioner Brown for purposes of our motion. Commissioner Brown.
Thank you, Mr. Chairman. Before the Commission for consideration is the initial decision issued in this matter. The complainant filed a formal complaint requesting a lower payment arrangement. The hearing was set for October 10th, 2013. On October 7th, 2013, the complainant faxed the Office of Administrative Law Judge a request that the hearing be canceled because he was unable to take the time off from work. On October 8th, 2013, the complainant faxed another request for a continuance. The ALJ denied the complainant's request because the complainant failed to comply with the July 30th, 2013 pre-hearing order, which stated that any request for a change of the scheduled hearing date must be submitted no later than 5 business days prior to the hearing and would be granted only for good cause. The complainant did not attend the hearing, and the ALJ dismissed the case with prejudice for failure to carry the burden of proof. I note this commission has long recognized that some leniency must be afforded to complainants who appear before us without the benefit of legal representation. Pro se complainants cannot be expected to be as well versed in administrative and legal processes as the attorneys in the utility bar who appear before the commission. Given Mr. Merrigan's apparent good faith attempts to continue the hearing, I believe that the complaint in this case should be dismissed without prejudice, not with prejudice. Therefore, I move that the initial decision be modified consistent with this motion, and the Office of Special Assistance prepare an opinion and order consistent with this motion.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
Mr. Chairman and Commissioners, that concludes the presentation of regular agenda items. Turning now to the carry-in agenda. It is recommended that the Commission adopt, on behalf of the Office of Special Assistance, the recommendations in the complaint proceeding involving Keisha Dorsey versus Philadelphia Gas Works, as well as the recommendation in the general rate increase proceeding involving People's TWP LLC.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
On behalf of the Law Bureau, it is recommended that the Commission adopt the staff recommendation to issue a final order in the Gas Beyond the Mains proceeding involving our jurisdictional natural gas distribution companies, noting the statement of Commissioner Whitmer.
So moved.
Second.
I'd like to recognize Commissioner Whitmer for purposes of her statement. Commissioner Whitmer.
Thank you, Mr. Chairman. And I'd like my statement entered into the record as if I had read it in its entirety. Before the Commission is a final order addressing the tentative conclusions regarding the future of UGI Utilities' existing tariffed Gas Beyond the Mains programs. With this order, we conclude a process that began over 4 years ago. On January 8, 2009, the Commission initiated an informal, non-prosecutory investigation into the status of the company's existing Gas Beyond the Mains programs in order to determine whether they should be allowed to continue into the future. Upon review of the 2010 report by several of the Commission's bureaus, as well as the comments received in response to our tentative order entered earlier this year in July, I believe the Gas Beyond the Mains programs, while well-intentioned, has outlived its usefulness. The burgeoning development and aggressive expansion of the company's service territory due to the availability of gas from Marcellus Shale has rendered this program out of date and unnecessary. Accordingly, I fully support the Commission's recommendations to dissolve Gas Beyond the Mains for individual tank service customers upon the conclusion of the August 2014 billing cycle, to discontinue the use of Gas Beyond the Mains for new piped propane service customers, and to disallow the companies to enroll any additional individual tank service Gas Beyond the Main customers as of the entry date of this order. In addition, I support the determinations that adequate notice and customer education must be provided directly to affected customers by the companies so that individual tank service Gas Beyond the Main customers fully understand the options available to them in the coming months. I cannot stress enough the importance of this education piece. Additionally, successful implementation of this final order is dependent upon UGI and PNG's compliance with the process and any applicable deadlines set forth in the order. I firmly believe that the benefits defined in this order to Gas Beyond the Main customers are significant. The affected customers will be able to freely choose their propane suppliers going forward. They will no longer be tied to the companies or their distribution rates, and they will be eligible for a one-time payment of $1,500 in order to assist in the transition to non-jurisdictional service. It is also worth noting that, in my opinion, the end result properly balances the interests of individual tank service gas beyond the main customers with those of the UGI and PNG ratepayers who have been subsidizing gas beyond the main customers for many years. Our action here today provides additional benefits for individual tank service customers that were neither available nor contemplated in UGI's 2009 1307F proceeding or PNG's 2009 base rate case settlements. As such, I fully endorse and support the final order. As I've stated in many proceedings, I strongly believe it's necessary for the Commission to periodically review not only the Public Utility Code and our regulations, but also utility-run programs in order to determine whether or not they remain necessary, relevant, and beneficial for consumers given market changes. This case is a prime example of why the Commission can and should revisit, and when necessary, conclude programs when they are no longer effective, so that greater benefits flow to Pennsylvania consumers. Thank you, Mr. Chairman.
Thank you, Commissioner Whitmer. Any further discussion? Any objections? Hearing none, the motion passes unanimously, noting Commissioner Whitmer's statement.
Mr. Chairman and Commissioners, that does conclude the presentation of agenda items.
I believe we have no further items to come before the commission here this morning, except for a
Your special-
retirement announcement, but we're
Your
going to do that after we bang the gavel. On behalf of my colleagues and I, I'd like to wish everybody a very safe and enjoyable Christmas holiday. And want to again thank our staff for a great year. We've gotten a lot of good work done here. 2014 is shaping up to be an even busier year. But without your support and without the dedication of the professional staff of this wonderful commission, this work wouldn't get done. So thank you so much for a great year.
Second.
Second that. You want to associate yourself?
I'll associate myself with your statement, Mr. Chairman.
All right. On that note, we're adjourned.